Great, thanks very much, Jess, and thanks, Jess, thanks, Jamie, and all the team at WHVP for having us on your webinar today. It's a real pleasure to collaborate with you. My name is Matthew Smith. I'm the General Manager of Southpac Group. Now, we are based in New Zealand, but our genesis really was in the Cook Islands. We've been operating out of the Cook Islands since 1982 and have set up several thousand Cook Islands trusts for clients, mainly US clients, although we do have clients all over the world. And we've been doing this now for the last 40 years. Today, myself and my colleague Guy Carson, our Head of Banking, Investment and Commercial Services, will be presenting on the benefits of offshore asset protection, different types of structuring that clients can use to achieve asset protection, and then going into a little detail about the key benefits of the Cook Islands as a jurisdiction, and then how to set up and operate Cook Islands trusts in conjunction with Swiss bank accounts, which is a structure many of our clients use very successfully. So with that, I'll hand over to Guy, who's going to kick off the presentation and introduce himself.
Excellent, thanks Matthew. So my name is Guy Carson. I'm the Head of Banking, Investment and Commercial Services here at Southpac. So part of my role is working very closely with WHVP, setting up Swiss bank accounts and working with them as an investment advisor. I also manage our onboarding process and our onboarding team. So I'll run through a little bit of that in the course of this presentation. But kicking off with the next slide. So who needs asset protection? Well, we would say everyone. Of course we would. We're in the business of asset protection. But it is a very important thing for high net worth individuals at some level, and Matt will run through the different levels of asset protection shortly. One of the areas, geographical areas that Matt mentioned is the US. We do have clients all around the world, and everyone around the world does need to think about asset protection, but those in the US particularly need to think about it. Part of the reason is that 65.5 million US court cases were filed in 2022. So there is a lot of litigation happening, a lot of people at risk. If we look at the history of Southpac, historically we had a lot of medical specialists. This going back sort of 10 to 20 years. A large part of our client base was medical specialists. Now, and a lot of those were particularly coming towards retirement. And the reason behind that is medical specialists, physicians can actually be sued up to 7 years after a procedure. So if you don't want to pay your higher insurance because you're no longer working, and the insurance can run into the tens of thousands up to the hundreds of thousands, depending on which what you're specializing in, you can still be sued after you retire for up to 7 years from a procedure that happened. Obstetricians are particularly at risk because that 7 years to sue actually kicks in when the child hits 18 years old. So theoretically, an obstetrician can be sued for up to 25 years after they retire. So going back 10 to 20 years, that's what our client book looked like, a lot of medical specialists. What we've seen now is quite a big shift. And the area we've seen a shift to is we've seen more and more business owners and entrepreneurs come into our client base. And there's a stat up there that approximately 50% of businesses are sued every year. So what we see is a lot of successful entrepreneurs set up a business. They're doing really well for a number of years. Someone sees they're doing well and decides they have a case against them, whether it's an ex-business partner, whether it's a contractor, whether it's a supplier. So we see this a lot. They come to us, they want to protect their assets, they want to protect their business, which they've built up over a period of time. So that's really why we're seeing a lot of demand from entrepreneurs and business owners at the moment. Whilst on the slide, I do want to highlight one common mistake we see. Quite often a client will come to us worried about one particular event. They're worried about one particular creditor coming after them. And when that passes, they decide, oh, I don't need asset protection anymore. So they've set up a trust to protect against this one thing. It passes, they say, hey, I don't need it anymore. I'm going to wind down my trust. A year or two pass and they come back to us and say, oh, I've got into a car accident or someone has tripped on one of my rental properties. And unfortunately, because they've wound down the trust, their assets are no longer protected and they're vulnerable to that particular claim. And you can see there's different types of awards there on the slide. and it can be quite significant. The two I highlighted were vehicle liability and premises liability. These things can come out of nowhere, and if you don't have the asset protection in place at the time, you're not going to be protected. So that's a really common risk that we see. All right, I'll pass over to Matt now.
Okay, thanks, guys. So on the next slide, which I'll run through briefly, we've got a little sliding scale of asset protection solutions. Now, there's not one size fits all for asset protection. Different clients will have different needs and different levels of protection that they want to secure. Now, generally speaking, starting from the left and moving on to the right-hand side of this slide, you're getting higher levels of protection. So right down on the left-hand side, we've got the revocable living trust, into which settlers can place assets or take assets back out at any time. Not a particularly protective option. IRAs and homestead protection provide some levels of statutory protection from future creditors, and are safe in the event of bankruptcy up to certain levels. So different states have different levels of homestead protection. And then as we move up, we've got LLCs, which are popular particularly for US clients, maybe limited companies used by other clients in other jurisdictions. And then we move on to irrevocable trusts. Now, these are generally much more protective than revocable living trusts, because once a settler places assets into an irrevocable trust, they don't have the power to just simply remove those assets back out at any time, meaning that they can't be directed by a court to pull the assets back out of the trust because the terms of the trust don't allow it. And then in terms of the types of irrevocable trust you get, you will often have some that have specific protection features. So DAPT stands for Domestic Asset Protection Trust. Again, this is geared towards US clients, but there are over 20 states now with their own domestic asset protection trust laws, which may have shorter statutes of limitation in terms of creditor claims, or have specific protected properties in the legislation. Now, these can work well in many circumstances, but if you've got maybe a trust in one jurisdiction, a settler living in another state, a beneficiary in a third state, and trust assets in a fourth state, you've got a lot of uncertainty there. Not all of those states may recognize domestic asset protection trust laws. If you've got a creditor judgment in one state, that may well be upheld in another, despite the existence of the domestic asset protection trust. And case law has shown that there is a lot of uncertainty. It's hard to predict how protective these will be in many cases. So moving to the right-hand side, you have the option of the foreign asset protection trust, or the offshore asset protection trust, as it may be known. And that's the space where we do a lot of our work in both the Cook Islands and Nevis, where we also have an office. And but the laws of both those jurisdictions have very protective provisions for trusts. And these work particularly well if the assets of the trust are also offshore. So this is why we often find clients who want to have cash and investments protected within a trust structure will open up a Swiss investment account underneath the trust, so that you then have the trust and the assets of the trust offshore. So very hard for creditors to claim against, or any US court or a court of another jurisdiction to assert jurisdiction over. And in the next slide, I'm going to focus on the Cook Islands in particular, as that's the focus of this presentation, and just run through some of the laws there that make the Cook Islands such a protective and safe jurisdiction for clients to hold their assets. So the main statute governing Cook Islands trusts is the Cook Islands International Trusts Act 1984. And this was developed during the 1980s. Actually, Southpac worked with a number of US asset protection attorneys back then to develop and strengthen the asset protection laws in this piece of law even further. And whereas there's a lot of features within the Cook Islands legislation that are common to other offshore trust jurisdictions, what really sets it apart is the protective features, which I'll just summarize here. So any assets that a client places into a Cook Islands trust before a cause of action arises, so before anyone has got a reason to sue them, those assets will be fully protected from any future creditor. There's no prospect of a creditor claiming that there was a fraudulent intent if that creditor didn't exist or have a reason to sue the settler of the trust at the time the trust was established and the assets were settled into it. Even if a creditor, there is a potential creditor who may have a claim against you, if assets are placed into the trust more than 2 years after that cause of action has accrued, again, those assets will be completely protected. That statute of limitation has expired. And if a creditor is seeking to make a claim against any assets placed into a Cook Islands trust, and to try to argue that those assets were transferred fraudulently, there's a number of very high hurdles they have to clear. First of all, they have to bring those proceedings in the Cook Islands. The Cook Islands does not recognise foreign judgments that are inconsistent with its trust laws. So a creditor may obtain a judgment in a US or other court, effectively stating, well, in that court's opinion, there was a fraudulent transfer and the funds must be returned. But the court doesn't hold jurisdiction over the trust or over the trustee or over the trust assets if they're offshore. And so under Cook Islands law, the creditor has to then bring proceedings in the Cook Islands, start proceedings again, instruct Cook Islands attorneys and attempt to persuade a court there that the transaction was fraudulent. They also have to have brought a claim relating to the original cause of action in their home jurisdiction within 1 year of the assets being placed into the trust. So this is an additional reason that often a creditor claim will be hopeless against a Cook Islands trust because they've not brought the proceedings quickly enough in their home jurisdiction. And then there are a couple of really key elements that a creditor must satisfy to show a court in the Cook Islands that a transaction was fraudulent. And they have to satisfy the court beyond reasonable doubt. That's to the criminal standard of proof, not just on the balance of probabilities. So firstly, they have to persuade the court that the principal intent that the settler had when they settled assets into the trust was to defraud that particular creditor who is bringing the claim in the Cook Islands. The creditor also then needs to show that that settlement into the trust left the settler unable to satisfy that creditor's claim. So if a client places 5 million into a trust, but they retain 5 million outside of the trust, and there's a creditor with a $2 million claim against them, the Cook Islands court will not allow the trust assets to be disturbed by that because the settler still had $5 million left at the point of settlement, and that's ample to pay the claim. So that's a brief rundown of the Cook Islands trust law. There is a lot of clients we find who want to retain a bit of extra control over the trust. Will set up a limited liability underneath the trust. And at Cook Islands law, LLCs also provide additional levels of protection. They provide that the only remedy for a creditor making a claim against an LLC is to come to the Cook Islands and obtain a 5-year charging order from the Cook Islands High Court. This charging order does not give a creditor any rights to make decisions in relation to the company or to force distributions. It just means that if a distribution is made, then depending on the proportion of that charging order, some of that will go to the creditor. If no distributions are made during that 5 years, the charging order lapses and it can't be renewed and the creditor goes away empty-handed. So we see a lot of clients who use Cook Islands trusts in conjunction with either a Cook Islands limited liability or a Nevis limited liability underneath the trust. Nevis has, as with trusts, Nevis has very similar laws to the Cook Islands when it comes to LLCs and their protective features. And in fact, Nevis is slightly more protective on the LLC side. And the next slide, I won't go through in detail, but it's one to look at afterwards. It's just a flow chart that summarizes the steps that I've just discussed on the previous slide, and sort of just runs through those, so it's a little easier to understand and refer to. I'm going to hand back over to Guy now, who's going to move on to the next slide around bank accounts, Swiss accounts.
Excellent. Thanks, Matt. So Matt has just spoken about the Cook Islands and its asset protection laws, and it really is a leading jurisdiction in that space. Now, we think we've got a long track record in asset protection. It goes back to the 1980s. Southpac was founded in 1982. The Trust Act, which Matt is talking about, Southpac was actually part of forming, and that came about in 1984. So we consider that a very long track record. Unfortunately, it's dwarfed by Switzerland and its banking history, which obviously dates back to the 15th century, and some of the existing banks actually date back to, I believe, the 18th century. So Switzerland has very much got a strong track record and really a leading banking jurisdiction. So when we combine the two, the asset protection of the Cook Islands and the banking of Switzerland, we really think you're getting the best of both worlds. Leading asset protection and leading banking. So it's a very strong offering. Also want to touch on that final bullet point on the privacy side. There's no public register in both jurisdictions, so you still protect your privacy and you get the benefits of both sectors, the asset protection and the banking. So moving on to the next slide. And we're just going to talk a little bit about how we set up a trust and how we maintain a trust going forward. So on the setup side, we will ask for quite a bit of due diligence up front. Unfortunately, there is no way to get around that. We do need to know our clients and where their wealth comes from. So up front, we'll ask for application forms, passport copies, proof of address, plus obviously FATCA CRS forms are very important in this day and age. The application forms will also include KYC information, know your client. We need to, as I mentioned before, we need to know our clients, where their funds are coming from. There's a high risk in the offshore space and things like money laundering. So we have to be very conscious of the AML laws. So once we have all the due diligence, we will move forward and draft the necessary legal documents that we need for a trust. That's typically a trust deed. And if there is an LLC involved, which Matt talked about, there will be an operating agreement and any other legal documents that may be needed just to establish. But those are typically the two that we do. Once everything is in place, we've got your KYC information, compliance comes in. No one likes compliance, but it is very necessary. We will do compliance checks and approvals. And once that's passed, we'll be sent off for registration. And the registration process in the Cook Islands can be very fast. It can be really 24 to 48 hours from when we send it. We can get those back. Sometimes on the same day, in fact, but 24 to 48 hours is our usual guidance. So once we've got the structure registered, we'll then reach out to Jamie and her team, and we'll work with them to set up an account at a bank that we'll choose together with them, and we'll appoint them as advisor to that account. So Southpac remains a trustee. We'll have a bank account in Switzerland, and WHVP will be the advisor to that account. As trustees, Southpac will still have oversight of everything that is going on, but WHVP will manage the investments. So that's the idea of how things are set up. I'm going to hand back over to Matt for the next slide on how to operate it moving forward.
Thanks very much, Guy. Yeah, so you've got the trust set up, you've got the bank account opened, you've got we've got the investment advisor, WHVP in place, and you're ready to go. So what next? Well, there's a number of things that need to be observed to successfully operate an offshore trust. And one of the key things to be mindful of is if you're the client, if you're the settler who's placing the assets into the trust, you have to remember that you are transferring ownership of those assets to the trustee, to a third person. That's how trusts work. The trustee owns the assets, and holds them and must use them for the benefit of the trust beneficiaries. So trust settlers have to maintain a relationship with the trustee that respects that fact that the trustee is the owner of those assets. Now, what we've seen, not just in our own experience, but come across case law and many examples in other jurisdictions, is situations where clients will place assets into a trust, and particularly if the assets are owned by a company owned by the trust that the client has can manage and has access to, and the client will just deal with those assets as if they are their own. They will take assets out, use them for their own benefit, not involve the trustee at any stage. And there have been occasions where in those situations structures have been challenged by the courts, and the courts have found that actually there was never a trust from the outset because the settler never had the intention to create a trust. The settler cut the trustee out of the loop. The settler just dealt with assets as if they were their own personal assets, and the court has effectively struck down the trust and said these assets are still owned by the settler and they're available to satisfy a creditor claim. So it's very important that the settler has a good and close relationship with the trustee. That's something we always promote. So when Guy and his team have finished with the establishment of a trust and the establishment of a bank account, the client will work with a member of our legal and client services team who'll be their ongoing point of contact. They are the person who will act on behalf of the trustee and be a point of contact here at Southpac, so that if the client is looking to request a distribution or have trust transactions that they would like the trustee to consider, they will liaise with that point of contact here. This ensures that there's the client's wishes are taken account of. Ultimately, the final decision on any action lies with the trustee, and that's the way it has to be to maintain the integrity and the protection of the trust. So, for example, when a client places assets into the trust, they would let the trustee know, or let their point of contact at Southpac know, I'm looking to place these assets into the trust. We would liaise with them to set up, put together a deed of gift. That's a document that records the acceptance of those assets into the trust by the trustee. That is what's required to ensure that legally those assets are recognised as sitting within the trust fund. Now, occasionally we'll get situations where Southpac is one of a number of trustees. Often there will be just one other trustee, often a US-based co-trustee. And where there is another trustee involved, that trustee may have a different set of powers. It's important for Southpac as the trustee in the Cook Islands to have that relationship and be able to share information with the US or other jurisdiction co-trustee. And so it's just important to maintain that flow of information between the client and the trustee, and between any other trustees. Another important thing to be aware of when operating an offshore trust is if you're a US person, there will be FATCA reporting requirements. If you're a non-US person, most likely there will be CRS reporting requirements as well. And for US persons, it's imperative that everything is tax reported properly. The IRS has been known to impose extremely stringent penalties on US clients who don't file the right forms or don't properly report trust income. So it's really important for clients to work with an experienced offshore CPA or CPA with offshore experience who can fully advise them on their reporting obligations. We have connections with a number of CPAs with offshore reporting experience. So if clients own CPAs, don't have that experience, we can make an introduction to somebody who does. And the key forms that US clients need to file every year in relation to offshore trusts are 3520As, which essentially report trust assets and any distributions, and then FBARs if the trust or further down in the structure holds any foreign bank account with more than $10,000 in, that must be reported. So yeah, that's a very important element that clients need to understand as well, is that depending on where they're tax resident, there'll be different tax reporting requirements, and that's something they need to understand up front. So that's our summary of kind of how to do it really, and how to make offshore Cook Islands trusts work in conjunction with Swiss bank accounts. On this slide here that Jess has just moved to, you'll see a little profile for myself and Guy, and also for Marcus Almeida, who is the head of our legal and client services team. As I mentioned, his team manage our client relationships and our points of contact for the clients sometimes during and especially after establishment. So this is who we are, and it's been a pleasure speaking with you all today, and I hope been an informative presentation. Thank you again, Jamie and Jess.
Thanks so much, Matthew and Guy. Really appreciate your guys' inputs into offshore trusts. I'll leave this slide up just for a little bit as we transition over to Jamie, so anyone can get a little bit more information on them and follow to their website if you need that. At the end, we'll be covering questions, so no need to worry. We've already got a few in the question and answer bar, so we're looking forward to getting to those. With that, I will turn over to Jamie Freihoff-de-Rose, who's going to take over and talk about Swiss bank accounts. So with that, Jamie, I will now turn over to you and let you carry on with Swiss bank accounts and what we do at WHVP.
Perfect. Thank you so much. As Jess already mentioned, my name is Jamie and I represent WHVP. We are a Swiss-based registered investment advisor, and as you have already heard from Matthew and Guy, we do collaborate with Southpac Group on helping US clients move money overseas. We do that in terms of offshore trusts, but there's also other reasons why people in the US are looking to move money overseas. Jess, if you could move on to the next slide. We see here what I'm going to cover in the next 10 to 15 minutes. I'll be talking about the various reasons people are looking to move money overseas. We will talk about international markets and why now is a particularly good time to consider diversifying. And then lastly, we'll also talk a little bit about Switzerland as a financial jurisdiction and Switzerland as a country to do banking in. So before we get started, one of the quotes that I like to share at the beginning of my presentation, because it represents very well how we think at WHVP and what our philosophy is. It's not about how much money you make, but how much money you keep, how hard it works for you, and how many generations you keep it for. So WHVP is a family-owned business. My husband and business partner and I took it over from my father, and we have the pleasure to work with clients who are the children of my father. And that's something that really is important to us. We have a long-term time horizon when we think about relationships and the portfolios that we build, and we really focus on the aspects of capital preservation and preserving a safe nest egg and the money that you have worked hard for throughout your career and that you would like to keep safe either for your retirement or to pass it on to the next generation. Now, moving on to the next slide, one of the reasons why people are thinking about moving money overseas is the fiscal responsibility of the US, or rather the lack thereof. So we have seen in the past 30 or so years since the 90s that debt levels has steadily increased and that we are at very unsustainable levels right now. And a lot of people perceive the Republican Party and President Trump as the fiscally responsible party. This is how they like to present themselves. But when we look at the numbers, we see that under the first term, under Trump, we have, or the US has added 8.4 trillion US dollars net to the debt. And that's something that we are most likely going to see during his second term. So even if we are generous and we take out the COVID relief packages, we are still at over 4 trillion US dollars added to an already very high level of debt in the first 4 years of Trump's presidency. If we move on to the next slide, we can see projections from the Committee for a Responsible Federal Budget. They are an independent organization. They are not tied to either party. They are not political in any sense, but they are looking at the numbers and the proposal that US politicians are putting out. and those are the estimates based on Trump's proposal. So we see that we are currently at almost 100% levels of debt to GDP, and that's projected to grow to around 143% on an average scenario under Trump. So what does that mean? That means that more money is going to be printed. That most likely means that there's more inflation going to hit the US. And when we look at the next slide, we can see what that does to the purchasing power of the US dollar. So this is a very long track record. Again, here in Switzerland, we like to think in centuries and decades and not in quarters. And when we look back to 1635, when the US dollar was first issued, it is almost it has been a downward trend for almost 300 years. So that's something to keep in mind. In the long term, the US dollar has lost value almost since its inception. And I understand that that's such a long time horizon that that's going to be very hard to conceptualize. And when we look here at the past 20 or 30 years, a time frame that we all remember and have lived through, it looks like it's almost a flat line. But if we move to the next slide, we can see what that looks like in the past 25 or so years. So to be fair, this is now not the US dollar value, but rather a comparison of the US dollar against the Swiss franc. But what we can see is that the US dollar has lost nearly 80% of its purchasing power against the Swiss franc over the past 25 or so years. Why is that relevant? If you are based in the US, most likely the vast majority of your assets and your investments are going to be held in the US and in US dollars. So if the US is fiscally irresponsible, if the US dollar is losing purchasing power, that's going to hit you, and that's going to hit you quite severely. You might not realize it if you don't have anything to compare it to, but the overall wealth, or like the purchasing power of your wealth, is not going to hold up. So one reason how you can combat this is through international investment diversification. Jess, you can move on to the next slide. So on top of having access to strong foreign currencies, like for example, the Swiss franc, which is a very popular safe haven currency, especially during times of geopolitical unrest, we can see here that right now is a particularly good time to invest in European markets, because the European markets have underperformed US markets in the past 15 or so years. And that's probably something that you have heard of in the news, something that you might be familiar with. And we believe that this is a very good investment opportunity because stock market levels are very inflated in the US at this time. And what we have also seen in the past few weeks is how volatile prices can be. So when we move on, one more slide, Jess, we can see here that we have extremely attractive PE ratios in Europe compared to an overheated market in the US. So we are not saying that there are no good investment opportunities in the US. There's certainly value in being invested in the US, but what we advocate for is diversification. So we advocate to move about 25 to 35% of your investable wealth outside of the US. So it is in a safe jurisdiction that doesn't have a problem with fiscal irresponsibility, that it is in a portfolio that holds foreign currencies that are going to appreciate against the US dollar and keep your purchasing power, and to make sure that you invest in markets that have long-term upwards potential and are not just driven or mainly driven by speculation and greed. Now, moving on to the next slide, please. I want to talk a little bit about Switzerland, because moving money overseas doesn't necessarily mean it has to go to Switzerland, but we believe that Switzerland is a quite unique country and offers a very great investment case to international investors, but particularly to US investors. So as we have already heard from Guy earlier today, we have centuries of track record in banking, in managing the wealth of wealthy private individuals. So we have started managing the wealth of aristocrats during the Middle Ages, and we have built on that track record over the years. One aspect that helped us grow is and was our military neutrality. So we have not been involved in any armed conflict in over 200 years. We were able to avoid both world wars despite them happening all around us. And even today, we are still an armed but neutral country. This led to over 240 banks operating in Switzerland. If you break that down to the population, this means we have the highest bank per capita ratio of any country in the world. This also means that about 25% of all money that is managed in another country than where the client lives is managed in Switzerland. Considering that we have a country with a population of about 9 million people and you can drive through the whole country in about 4 hours, that's quite impressive. We also have an exceptional education system that allows very young kids to go into corporate and commercial banking. So we have bank apprenticeships that start at 15 or 16 years old, and that also allows for people who work at banks to really gain a lot of practical experience early on and then to continue working while getting their university degree. So it's not uncommon to have people who are 25 or 30 years old who already have 10 to 15 years of practical experience. And then, of course, our country prides itself in our professionalism, integrity, and also privacy protection. So the Swiss have a culture that really highly values privacy. We have the bank secrecy law that was established in 1934 that is still in place today. No noisy family member or neighbor is going to be able to pry any information out of your Swiss bank account. Having your wealth be less visible in the US is going to put less of a target on your back. Of course, we have already heard it in the presentation earlier. This does not go towards the IRS, so you cannot use a Swiss bank account to hide money from tax authorities. But other than that, no one is going to have unauthorized access to your information. We also have very good data protection laws in Switzerland that will make sure that none of your information is used or even sold behind your back. We also have very strict federal laws when it comes to the financial services industry, when it comes to laws and things like an equivalent to FDIC. So your money is really very highly protected in Switzerland over all different aspects. And then, of course, Switzerland is also a wealthy country. So we have a high GDP in comparison to the population that we have, and we have fairly low levels of debt. So we do have a debt break that keeps our debt steady at about 38 to 40% of our GDP. And then lastly, I've already mentioned it, we have the Swiss franc as a safe haven currency that is being managed by the Swiss National Bank, which has one single goal, that is price stability. So contrary to the Fed in the US, which has the goal of unemployment and price stability, which can sometimes cause a conflict of interest. We can move on to the next slide, Jess. Just a few parting words from my side before we head into the Q&A section. We know that it can be quite a complicated and complex topic. There's a lot to learn, and we only have about 45 minutes today, so we were only able to scratch the surface. But if you'd like to learn more, we invite you to check out our blog, which you can find on WHVP.ch. If you click on Insights there, you should be able to find it. You can find us on YouTube under WHVP again. And then we also have a podcast called Swiss Money Secrets. You can find that everywhere where you listen to your podcast. If you have any questions that go beyond the scope of the Q&A, or if you want to set up a complimentary consultation, then you are welcome to reach out to us at info@WHVP, and we will be happy to schedule a call with you. And now with that, I'm happy to hand it back over to Jess.
Perfect. Thank you so much, Jamie. I really appreciate the conversation and the information. So now we will roll over into the Q&A. This first Q&A is going to be for Matthew and Scott. The question, Matthew and Guy. The question is, could you please compare the Cook Islands to other well-known island trust jurisdictions, for example, the Channel Islands and the Laymans, etc.?
Yeah, so as I mentioned in the presentation, that there's a lot that the Cook Islands has in common with a lot of other well-known offshore trust jurisdictions. For example, there are good reserve powers for settlers. There's forced airship avoidance legislation. So there's a lot in common there. But what really sets the Cook Islands apart are those protective provisions. that I ran through in the presentation. So if you look at somewhere like the Cayman Islands, they have a much longer statute of limitations. I believe it's 6 years for the Caymans. Compared to the Cook Islands, where any assets that you place in before anyone's got a reason to go after you are going to be fully protected from the outset. There are also some other considerations. The reporting and regulatory requirements in a lot of the more traditional trust jurisdictions like Cayman and Channel Islands have really ramped up over the last few years. There's sort of fairly stringent economic substance for reporting requirements for companies that operate in those jurisdictions, and for the ones that have got a UK link, there are, while it's not fully public beneficial ownership registers, that there are centralized registers that can be accessed fairly easily on application by anyone who can show some sort of interest in accessing them, whereas the Cook Islands has very stringent privacy provisions. It's actually a criminal offence to divulge information about a Cook Islands trust or its dealings or settlers without lawful authority. So yeah, those are some of the key differences there, and we believe that the Cook Islands really stands sort of shoulder to shoulder with any of the other sort of more well-known trust jurisdictions throughout the world.
Great, thanks so much, Matthew. That's a great answer. Another question here, kind of on a jurisdiction side, is that you guys noticed that Nevis has a little bit slightly different LLC laws than the Cook Islands. Could you give some could you explain why or how they differ?
Yeah, if I take this one, the key difference is around that the duration of the charging order that I mentioned. So in the Cook Islands, the maximum duration of a charging order a creditor can obtain against an LLC membership interest is 5 years. In Nevis, it's only 3 years. So that's one of the key differences. And the other is actually that in Nevis, any person bringing proceedings in relation to an LLC, a creditor seeking a charging order, has to pay a bond into court. Which the amount can vary, but you're generally looking at around $50,000 needs to be paid into court just to get through the door and issue the proceedings there. So that's quite a significant difference. And one popular structure we see as a result is clients will have a Cook Islands trust which owns a Nevis LLC, having offices in both jurisdictions. That's something we can accommodate pretty easily.
Perfect. Yeah, thank you. The follow-up question to that is, what are the initial setup and annual trustee fees, not counting U.S. legal or accounting, so for your guys' services?
Yeah, so we've been working on sort of introducing a new fee schedule lately. We've been trying to move more towards an all-inclusive fee model. So if you have an individual client who's coming to us, you're wanting to set up maybe a trust that's going to hold a managed Swiss bank account, we would put in a flat fee for that of you're starting at $12,000 a year. If we're working with referrers for that, then that amount can be discounted a fair bit. So, for example, if you guys had clients that were interested in moving into a Cook Islands trust model, then we'd be able to work with them for offer about $7,500 per year on an all-inclusive basis, and that would reduce the higher number of clients was referred.
Great. Jamie, I'd say follow up on that question. What are the costs of a Swiss bank account for what we're talking about, so they can kind of get a picture of what it looks like, not just with the trust, but also the Swiss bank account?
Yeah, absolutely. So we are the registered investment advisor. That means we work together with a custodian bank. The bank charges fees separately from us. The fees of the bank depend on which bank and the volume of the portfolio. They typically charge a custodian fee on the assets under management, and the same goes for us. So we charge an all-in asset management fee on the assets under management. The minimum investment volume to get started with a Swiss bank account is $500,000. For that, we charge 1.5%, and then that goes down if the portfolio becomes bigger. So it's 1.25% for 3 million and upwards, and then it becomes negotiable for 5 million and upwards.
Perfect. Thank you for that, Jamie. I think that's very helpful. Looks like we have one more question. So if you do, any of our participants, if you do have any last minute questions, make sure to get them in now. But this last question, unless something else comes in, is kind of how long does it take to set up a Cook Islands trust and a bank account, kind of on the package of what we're talking about today, Cook Islands Trust, Swiss bank account, what does the time frame look? So maybe Guy and Matthew, you could talk about the Cook Islands Trust side, and then Jamie, you could follow up with the Swiss bank account.
Yeah, absolutely. So to set up a trust, we can get it done. If everything goes perfectly, we can get it done in a week. That's from getting the due diligence documentation for us to review it, pass compliance, to get it registered. So we can do it in a week. I will typically say 2 weeks is around our median as average time. So 1 to 2 weeks, we can usually get most entities done. That, of course, doesn't take into account if there is circumstances in the KYC that we need to review further, and it does rely on us getting all the documentation up front, but 1 to 2 weeks to set up a trust.
Perfect. Yeah. Jamie, could you talk about the Swiss bank account?
Yeah, absolutely. So it depends a little bit on what kind of structure holds the account. So if it's a personal account or a joint account held by between two spouses, I would say about 3 to 4 weeks is a reasonable estimate. We can also do self-directed individual retirement accounts, so you can move those overseas without it causable a taxable event. That would be 3 to 4 weeks as well. And then for offshore asset protection trusts, or LLCs or any other sort of structure that are a little bit more complex, I would say 4 to 6 weeks is a more reasonable estimate, but it depends very heavily on how quick clients are in returning documents, signing everything they need to sign, like answering questions. And then, of course, if there are factors that make an account opening a bit more complex, or if there's follow-up questions that can make the process a little bit longer, but we are a boutique firm. We have very close relationships with every person that decides to work with us, and we guide every single person through the whole process step by step. So we try to make it as easy as possible and offer as much help as we can.